I have presided over thousands of cases, and I have heard people insult lawyers, witnesses, police officers, and even entire institutions. But only once did I watch a woman stand in open court, glare at the bench, and declare, "This court is a joke." She believed those words would shake the room. Instead, within 3 seconds, one simple question exposed a lie she had been telling from the very beginning. The silence that followed is something I still remember with absolute clarity. Before we go any further, make sure you have subscribed to this channel for more powerful courtroom stories like this one. And if you haven't subscribed yet, do it now. Also, comment below and tell us where you are watching this video from. Now let me take you back to where this case truly began. My name is Judge Judith Harper. If my years on the bench have taught me anything, it is this. People rarely destroy their own credibility with one enormous mistake. More often, they do it with a series of small decisions, a misleading statement here, a convenient omission there. Eventually, those pieces no longer fit together. This case began as a dispute over a luxury vehicle. The plaintiff was Karen Foster, 46 years old, well-spoken, confident. A successful marketing consultant who claimed she had purchased a pre-owned luxury SUV from a local dealership after being assured it had never been involved in a serious accident. The defendant was Daniel Brooks, the dealership's general manager. A former Marine whose calm demeanor never seemed to change, even under aggressive questioning, Karen alleged that the dealership had intentionally deceived her. She claimed the vehicle suffered from hidden structural damage that made it unsafe to drive. She demanded compensation for repairs, lost income, and emotional distress. At first glance, the case appeared compelling. Consumers deserve honesty. Businesses must disclose material defects. Those principles are fundamental, but courtroom experience has taught me something equally important. The first story is rarely the complete story. As Karen testified, she spoke with remarkable confidence. Every answer came quickly, almost too quickly. She described discovering problems only weeks after buying the vehicle. She insisted she had never been warned about prior damage. She repeatedly stated she would never have signed the purchase agreement had she known the truth. The jury listened attentively. So did I. Then I looked toward Daniel Brooks. He wasn't reacting, no frustration, no visible anger. He simply sat quietly reviewing a folder filled with documents. That immediately caught my attention. People who know evidence is coming often remain surprisingly calm. Karen continued describing how betrayed she felt. At one point, she looked directly toward the jury and said, "I trusted them completely." It was a powerful sentence, emotionally persuasive, but powerful statements require powerful proof. The defense attorney stood and walked to the evidence table. He picked up a thin file, not a thick binder, not dozens of exhibits, just a single folder. Years on the bench have taught me that the smallest folder sometimes contains the biggest problem. He requested permission to introduce Defense Exhibit 7. I granted it. Karen smiled confidently. She appeared completely unconcerned. That confidence intrigued me, because if she truly did not know what was inside that folder, she had nothing to fear. But if she did know, everything was about to change. As the exhibit appeared on the courtroom screen, I noticed something I never ignore. Karen's smile disappeared. Only for a moment, just long enough for an experienced judge to notice. And in that brief moment, I realized this trial was no longer about a damaged vehicle. It was about whether the plaintiff had told the truth from the very first minute she entered my courtroom. What happened next would unfold so quickly that the entire case would change in less time than it takes to count to 3. The second day of trial began with an atmosphere that felt noticeably heavier than before. Not because anyone had raised their voice, not because dramatic evidence had already been revealed, because everyone in the courtroom sensed that Defense Exhibit 7 was important, very important. Karen Foster entered with the same polished appearance she had maintained since the trial began. Professional attire, confident posture, measured smile. She projected certainty. Daniel Brooks entered carrying the same folder he had carried the previous day. He placed it carefully on the defense table without saying a word. Years on the bench have taught me something curious. People often reveal their confidence through silence more effectively than through speeches. The defense attorney requested permission to continue his cross-examination. I granted it. He walked toward the evidence screen and displayed the first page of Defense Exhibit 7. It was not a repair invoice, not an inspection report, not a mechanic statement. It was the original purchase agreement Karen had signed on the day she bought the SUV. At first glance, it appeared ordinary, standard legal language. Several initials, multiple signatures, boxes checked throughout the document, nothing dramatic. Yet the attorney began with simple questions. Mrs. Foster, is this your purchase agreement? Yes. Is that your signature at the bottom? Yes. Were you given time to review the agreement before signing it? Karen nodded. I was. Every answer came quickly. Confidently, the attorney thanked her. Then he enlarged one section of the agreement, a paragraph highlighted in yellow. The jury leaned forward. So did several spectators. The paragraph referenced a vehicle history disclosure. Karen shifted slightly in her chair, just slightly, but after decades on the bench, I have learned that small movements often carry enormous meaning, the attorney continued. Miss Foster, would you please read the highlighted sentence aloud? Karen stared at the screen. She didn't begin reading immediately. That hesitation lasted only a few seconds, but in court, a few seconds can feel like an eternity. Finally, she read the sentence. The purchaser acknowledges receiving and reviewing the vehicle history report before completing the sale. Her voice grew quieter near the end. The courtroom remained silent. The attorney asked his next question carefully. Did you just read those words accurately? Yes. And immediately beneath that paragraph, whose initials appear? Karen looked again. There, mine. Another admission, another piece falling into place. I watched the jury. Several members immediately wrote notes. One looked back and forth between the agreement and Karen. Another folded his arms and leaned back, studying her expression instead of the document. Jurors don't simply evaluate evidence. They evaluate reactions. Karen attempted to explain. She said the paperwork had been rushed. She claimed she trusted the dealership and signed where she was instructed. That explanation was possible. But explanations become less persuasive when they directly conflict with signed acknowledgments. Years on the bench have taught me that contracts are not magical documents. People can misunderstand them. People can be misled. But when someone repeatedly initials specific disclosures and later insists they never saw them, the court must ask difficult questions. Then the defense attorney reached into the folder one more time. He removed a second document. Smaller than the first. Only a single page. He held it up briefly before placing it on the evidence projector. I immediately recognized what it was. A separate acknowledgement form, one that required its own signature. Karen's expression changed again. This time, she didn't even try to hide it, because she knew exactly what that page contained. And within moments, the courtroom would discover why the defense had waited until now to reveal it. That single sheet of paper would bring Karen's entire story to the edge of collapse. The third morning of trial began with an unusual calm. Sometimes that happens just before everything changes. The previous day had ended with the defense placing a single-page document onto the evidence projector without discussing it. That was no accident. Experienced trial attorneys understand timing. Evidence introduced at the right moment often speaks louder than the most passionate argument. Karen Foster entered the courtroom looking composed. She smiled briefly at her attorney, straightened a stack of papers, avoided looking toward the defense table. Daniel Brooks remained exactly as he had throughout the trial, quiet and fixed. I watched both of them carefully. Years on the bench have taught me that anticipation often reveals itself through silence. The defense attorney requested permission to continue. I nodded. He walked to the evidence screen and enlarged the document. It was titled Asterisk Vehicle History Report Acknowledgement, a separate disclosure, independent from the purchase contract. The attorney spoke slowly. Mrs. Foster, do you recognize this document? Karen looked at the screen. Yes. Is that your signature? Another pause. Then she answered. Yes. The attorney thanked her and continued. This acknowledgement confirms you received a copy of the vehicle history report before purchasing the vehicle. Is that correct? Karen shifted in her chair. I signed a lot of paperwork. It was not the answer to the question I noticed immediately. So did the jury. The attorney repeated himself. Does the document state that you received the report before completing the purchase? Karen looked toward her own attorney before finally answering. Yes. The room remained silent. Then came another exhibit, the actual vehicle history report. Every page carried a timestamp. Every page had Karen's initials at the bottom. Not one page, every page. I watched the jurors carefully. Several leaned forward. One adjusted his glasses to read more closely. Another slowly compared the initials from the acknowledgement form with those on the report itself. Years of judging have taught me something simple. One document may create doubt. Several independent documents create patterns. And patterns are difficult to dismiss. The defense attorney walked toward the witness stand, not aggressively, calmly. He asked one question. Mrs. Foster, yesterday you testified under oath that you never saw this report before purchasing the SUV. Do you remember saying that? Yes, and today you've acknowledged signing a document, confirming you received it, and initialing every page of the report itself. Correct? Karen hesitated. The hesitation lasted only a few seconds. But everyone noticed. Yes, the contradiction now existed in plain view, no complicated legal theory, no technical interpretation, just two statements that could not both be true, Karen tried to explain. She said she didn't actually read the report. She assumed it contained routine paperwork. Perhaps that was true, perhaps not. But that wasn't what she had testified to. She hadn't said she failed to read it. She had said she never received it. Those are very different claims, very different. I leaned back slightly in my chair. In my years as a judge, I have learned that credibility is rarely lost all at once. It erodes one inconsistency at a time, one contradiction at a time. Frustration finally overcame Karen. She threw her hands into the air and looked directly toward the bench. This court is a joke! The words echoed across the courtroom. No one spoke. No one moved. She seemed convinced the outburst would shift attention away from the evidence. Instead, it did exactly the opposite, because within the next 3 seconds, I would ask one simple question. A question so direct, so undeniable, that it would expose the biggest lie in her testimony before anyone in the courtroom had time to catch their breath. The instant Karen Foster declared, "This court is a joke," the room fell into complete silence, not the uneasy silence of confusion. The absolute silence that follows when everyone realizes a line has just been crossed. I did not respond immediately. That often surprises people. They expect emotion. They expect outrage. Years on the bench have taught me that the most effective response is often the calmest one. I simply looked at Karen. She was breathing heavily. Her frustration was obvious. She believed the evidence had trapped her unfairly. But evidence does not trap people. Their own words do. I let 3 seconds pass. 1, 2, 3. Then I asked a single question. Ms. Foster, is that your signature? I pointed toward the acknowledgement form displayed on the screen. Nothing else, no speech, no lecture. Just one question. Karen turned toward the monitor. She stared at it. The courtroom waited every juror, attorney, every spectator. Finally, she answered. Yes, the effect was immediate. Years on the bench have taught me that sometimes the shortest exchange carries the greatest weight. Because 3 seconds earlier, Karen had insisted this court was the problem. Now, with one admission, she confirmed the document was genuine. The courtroom remained perfectly still. I asked another question. And are those your initials on each page of the vehicle history report? Karen closed her eyes briefly, then answered, yes, there it was. The contradiction required no explanation. She had testified that she never received the report. Now she had admitted signing the acknowledgement and initialing every page. The jury did not need legal training to understand what that meant. I watched several members exchange quick glances. One juror slowly set down a pen and folded both hands on the table. Another leaned back, never taking his eyes off Karen. Those small reactions often reveal more than words. Karen tried to recover. I didn't actually read it. Her attorney looked down at the table. The defense attorney said nothing. He didn't have to. The distinction was obvious. Not reading a document is very different from claiming you never received it. That difference had become the central issue in the case. I addressed Karen carefully. Ms. Foster, yesterday you testified under oath that the dealership never provided you with the vehicle history report. Yes. Today you've acknowledged signing a document confirming receipt and placing your initials on every page. Another pause. Yes. No argument remained. No explanation erased those admissions. The courtroom atmosphere changed completely. Until that moment, the case had centered on whether the dealership had been honest. Now it centered on whether Karen had been. Years of experience have taught me that juries forgive mistakes. They sometimes forgive poor memory. They even forgive confusion. But deliberate contradictions are much harder to overlook. Karen sat down slowly. The confidence she displayed at the beginning of the trial had vanished. For the first time, she stopped looking toward the jury. Instead, she stared quietly at the table in front of her. The defense attorney returned to counsel table without another question. He understood something important. When evidence has already spoken, additional argument often weakens its impact. But the trial was not over. Not yet. Because one final witness was about to testify. A witness whose testimony would determine whether Karen's contradiction was merely a misunderstanding or something far more serious. And when that witness took the stand, the entire courtroom would finally learn the truth behind the document Karen claimed she had never seen. There is a point in some trials when the courtroom no longer waits for dramatic surprises. It waits for confirmation. That was exactly where we stood. Karen Foster had admitted the signature was hers. She had admitted the initials on every page were hers. She had admitted signing the acknowledgement stating she received the vehicle history report, yet only a day earlier, she had testified that the dealership never gave it to her. The contradiction now belonged to the record. Nothing could erase it. The defense called its final witness, a finance manager named Emily Bennett. She had worked at the dealership for 11 years. Professional, organized, calm under pressure. She carried a thin folder to the witness stand. Not because she needed it to remember, because good record-keeping had become part of her routine. After taking the oath, she explained her role in every vehicle sale. She personally reviewed financing documents, title paperwork, warranty disclosures, and vehicle history reports with customers before any transaction was completed. The defense attorney asked a straightforward question. "Did you handle Ms. Foster's purchase?" "Yes. Do you remember it?" "I do." Karen watched silently. For the first time since the trial began, she did not interrupt. Emily explained that Karen had asked numerous questions during the purchase. She was careful. She wanted clarification on financing terms, extended warranty options, and previous maintenance records. That testimony immediately caught my attention because it painted a very different picture from someone blindly signing paperwork. Then came the crucial moment. The attorney asked Emily to describe the vehicle history report. She smiled politely. "I always place it on top of the closing documents." "Why?" "Because company policy requires me to review it before any customer signs the purchase agreement." She then identified her own initials on the acknowledgement form. Next to Karen's, the timestamps matched, the transaction log matched. Even the digital scanning record showed the report had been printed only minutes before Karen signed it. Years on the bench have taught me that independent records are extraordinarily persuasive. One document can be questioned. 3 documents from separate systems become much harder to dismiss. Then the attorney asked Emily something unexpected. "Did Miss Foster ask any questions about the accident listed on the report?" Emily answered immediately. "Yes." The courtroom became still. Karen slowly looked up. Emily continued. She asked whether the repairs had been certified and whether the damage affected the vehicle's value. The defense attorney approached the evidence screen. A handwritten notation appeared on the sales worksheet. Next to the words * customer asked, about prior accident were Emily's initials, and the time of the discussion, Karen stared at the screen without speaking. That notation had been created months before the lawsuit. Long before anyone anticipated litigation. Long before anyone had a reason to invent evidence. I watched the jury carefully. Several members nodded, almost imperceptibly. The timeline now fit together perfectly. Karen had not merely received the report. According to the contemporaneous business records, she had discussed its contents before completing the purchase. That realization changed everything. I looked toward Karen. She appeared exhausted. The certainty that had defined her testimony was gone, because the evidence was no longer contradicting isolated details. It was contradicting the foundation of her entire case. At that moment, I realized the jury's task had become remarkably simple. The facts had aligned, the documents agreed, the witnesses were consistent. Only one question remained: would justice follow the evidence or the emotion? Within hours, every person in that courtroom would know the answer. The final morning of the trial carried a quiet certainty that had not existed when the case began. No one needed to guess where the central issue now stood. This was no longer simply a dispute about a used luxury SUV. It had become a case about credibility, about whether sworn testimony could withstand the weight of documentary evidence. Karen Foster sat quietly beside her attorney. The confidence that had filled her testimony during the first day had disappeared. She no longer looked toward the jury. She no longer reacted to every exhibit. She simply listened. Daniel Brooks remained exactly as he had throughout the trial. Calm, respectful, patent. His attorney delivered the defense's closing argument with remarkable restraint. There was no celebration, no personal attacks. He walked the jury through the evidence one final time. The purchase agreement, the signed acknowledgement. The vehicle history report, Darren's initials on every page, the dealership's transaction log. Emily Bennett's testimony, the handwritten notation documenting Karen's questions about the prior accident. Each piece fit together with the next. No gaps, no contradictions. Then Karen's attorney addressed the jury. He argued that people often sign paperwork without reading every page. He suggested that confusion should not be mistaken for dishonesty. It was a fair point. People do overlook documents. People do misunderstand contracts. But this case had moved beyond that, because Karen had not merely claimed she failed to read the report. She had testified that she never received it. That difference mattered. The jury retired to deliberate. As always, I reminded myself not to speculate. Judges do not decide civil juries' verdicts. We ensure the process remains fair. Nothing more, nothing less. Several hours later, the clerk informed me that the jury had reached a decision. Everyone returned to the courtroom. The atmosphere was tense. The foreperson stood. The verdict form was handed to the clerk. Then it was read aloud. The jury found in favor of Daniel Brooks and the dealership. Karen's claims were rejected in their entirety. The jurors concluded that the dealership had fully disclosed the vehicle's history before the sale, and that the documentary evidence overwhelmingly supported the defense. Karen remained perfectly still. No protest, no angry remarks. No accusations against the court. Only silence. Daniel quietly shook his attorney's hand. Relief appeared on his face, but there was no celebration. Only gratitude that the process had finally come to an end. Before dismissing the parties, I offered one final observation, not about automobiles, not about dealerships, about truth. I explained that every courtroom depends on trust. Witnesses promise to tell the truth. Attorneys promise to present evidence honestly. Judges promise to apply the law fairly. Jurors promise to decide cases based on facts. If any one of those promises is broken, justice becomes more difficult to achieve. Then I reflected on the moment that had changed everything. Karen's declaration that this court is a joke. Those words were meant to discredit the process. Instead, they became the turning point, because within 3 seconds, one simple question, "Is that your signature?" shifted the focus away from emotion and back to evidence. That is the remarkable thing about facts. They do not become weaker because someone insults the court. They do not disappear because someone raises their voice. They remain exactly what they are, pipe pound, consistent waiting to be examined. As I gathered the final exhibits, I looked once more at the acknowledgement form that had transformed the entire case. A single signature, a few initials. Nothing extraordinary, yet those ordinary markings carried more weight than hours of emotional testimony. That is why this case has remained with me. Because it reminded everyone in that courtroom, including me, that the strongest voice in any trial is never the loudest person. It is the evidence. And when the evidence speaks clearly enough, the truth only needs a few seconds to reveal itself.